Welcome, everybody. Thank you for joining us for another Cannabis Lab event. Today, we are here for critical legal updates in cannabis. It's an outstanding panel tonight. Before we get going into that, I just have a couple of updates for you, some announcements. First, I want to thank our event sponsor this evening, which is DeRay & Company. DeRay Ross has recently joined our leadership team with Cannabis Lab, and we are very excited to have her. So shout out to them. Thank you very much for supporting us and for sponsoring the event tonight. We also have two new sponsors, Midland Scientific, which is a full-line distributor of laboratory products. They help a lot of people in the cannabis and hemp space. And we also have HBK CPAs and consultants. They offer accounting and assurance services, and we're very excited to have them. So thank you for becoming sponsors of Cannabis Lab, and we look forward to your participation in the future. Tonight, we are live on Facebook. We would love it if you go out there and start your own watch party. Show us some love, help us grow. Also, if you've missed any of our recent events, if you've missed any of the great Elevate Your Grind podcasts, you can go to YouTube. We have our own YouTube channel now. Please subscribe. You can find us under Elevate Your Grind. There is amazing content from being uploaded every day from old previous conferences we've held, along with lots of our Elevate Your Grind podcasts, as well as these panels. With that, I'd love to turn it over to our moderator tonight, Mr. Dustin Robinson with Mr. Cannabis Law. For those of you who don't know him, first of all, I don't know how you don't know him yet. He is all over this space. He's very knowledgeable, both as an accountant, a CPA, and an attorney in this space. And as I said, he's the founder of Mr. Cannabis Law. So I'll hand it over to you, Dustin.
Thank you very much, Amanda. Thank you, CLAB, and thanks for the audience for being here. Like Amanda said, my name is Dustin Robinson. I'm the founding partner of Mr. Cannabis Law, and I will be moderating the panel. Today's topic is legal updates in cannabis. This year has been an evolving legal landscape for the Florida cannabis industry. We've had FDACS pass hemp rules that were approved by the USDA. So we now have hemp companies that are being licensed and permitted in Florida. We've also had the expiration of the dispensary cap in Florida Statute 381.986, which allows the MMTCs to essentially open up as many dispensaries as they want. And we also have the Florida Supreme Court considering the constitutionality of the vertically integrated structure for MMTC. So with this type of dynamic environment, it's important for our CLAB community to stay abreast of all the current legal developments, as well as, looking forward into the future. And that's the purpose of this panel, is to really get a legal update and look into the future. So before we jump into all the topics, I'm going to let each of the panelists introduce themselves. We're going to start off with Michael Minardi. So Michael, please tell us about yourself and what you do in the industry.
Hello, everyone. Nice to see some of you on here and seeing people in the chat come on. I think there's a lot of people that I'm not familiar with. Welcome to all of you. My name is Michael Minardi. I'm an attorney here in the state of Florida. Currently, we represent a bunch of people in regards to multiple different lawsuits challenging the issues that are going on here in the state of Florida. Number one, we're part of the Florida Grown lawsuit. Also, we're working on a lot of employment law issues at this point, and students getting kicked out of schools and stuff like that, that are seemingly occurring more and more often right now with people with medical cards, and I foresee that to be a continued issue with hemp. We also obviously represent people in criminal defense situations and are excited to be doing expungement clinics throughout the state of Florida with TrueLeave in September, free of charge for people, be able to get their records sealed or expunged so they could potentially get into the cannabis industry here in the state of Florida if they want to. Otherwise, we are focused on cannabis law, changing the law, reforming the laws, and waiting for the Supreme Court, in addition to the things that Dustin mentioned, but Regulate Florida, our legalization initiative for 2020. We're waiting for the Florida Supreme Court to determine the legality and the constitutionality of that, and then deciding how we're going to proceed with 2022. But I can assure you, either way, we are going to proceed with pushing for legalization again in 2022. So other than that, we're just a firm that loves this plant and can't wait to continue to see this industry involved here in the state of Florida, both cannabis and hemp, as we also have a lot of hemp clients that are getting into this industry. I'm really excited to see people able to start businesses as opposed to getting thrown in jail for it. So
Awesome. Thank you so much, Michael. Eric, you're up next.
Thank you, CLAB and everybody. Great panel lined up for tonight. So briefly, I'm Eric Stevens. I worked mostly on the United for Care Amendment 2 campaign previous to this in 2013. I worked on implementation with Florida for Care. I did some work with the testing lab, a hemp association, and now I really saw a lack of continued education on everything going on in Tallahassee. And so I've really tried to build back up what we built from the start to make sure we continue to implement this. We had to sue the state for smokable flower, and there's a lot of other things that are still working and continue to get better. And we want to focus on patients and physicians and that point of view and how that affects all of this. So thanks, Justin, and looking forward to chatting with everybody.
Absolutely. Zach, you're up next.
How's everyone doing? My name is Zach Coburn. I'm an attorney at the Ackerman Law Firm. I specialize in all cannabis matters, marijuana or hemp, represent a number of the MMTCs in Florida, as well as ancillary business providers, labs, hemp importers, and the like. So I work on both sides with the Department of Health as well as Department of Agriculture, and also work on regulatory matters in Florida and elsewhere. Previously, as many know, I was in-house counsel to one of the original MMTCs, and then after helping them go public, decided to go back to private practice and now represent a number of companies across. So I've been working in this space for a while and have a real strong understanding of the growth of the Florida market, probably almost as well as the next person speaking, because he's since the beginning.
Christian, right on cue. You're up next.
Oh, thanks, Zach. I appreciate that. That's very high praise coming from you. My name is Christian Bax. I was the director for the Office of Medical Marijuana Use from 2015 to 2018. I'm a regulatory lawyer now in the private sector. I'm out of Tallahassee. My practice generally is representing clients before administrative agencies and local governments and helping them understand things like rulemaking and variances. And I'm of counsel with the Lockwood Law Firm. We represent about between 40 and 50% of the market of the MMTCs in the state, depending on depending on the quarter. And I'm very excited to be here to talk to you guys today because there's a lot of very interesting stuff going on in the cannabis market, which is what about 90% of my regulatory practice is devoted to.
Awesome. Thank you, guys. I appreciate that. As you can see, we got a really good panel for us tonight. First, what I'd like to do is briefly touch on state and local elections. The elected officials are obviously the people responsible for new legislation. So Eric, why don't you give us an overview of what was just on the ballot and what to expect in November?
Yeah, so I think it all kind of ties in, and why I wanted to just touch on this briefly here is whoever gets elected are the ones that end up passing the bills, sponsoring the bills, being the heads of committees, and deciding what legislation gets heard or not. And so I think make sure that everyone kind of understands how that process works, what they need to do. There's a variety of things that are going to be changing for people, obviously, with just the COVID stuff. And I think everyone gets so focused on the presidential election some years that they don't realize there's 100+ House members, half of the Senate, almost all, all the Congress. Then we have local elections. For the most part, the primaries, which we just had on Tuesday, aren't that intriguing, or people aren't really paying attention, especially this year with everything else that's been going on. But occasionally you get some open primaries, and you're able to vote as not a registered Democrat or Republican as well, because otherwise, for the most part, the primaries are on those, or they're judges. There's some mayors, commissioners, property appraisers, other different positions like that. But there's a lot of important stuff that's going to be on the ballot up here in November. And I think the two most important, there's 6 constitutional amendments, 2 of which I think could have a profound impact on the future of any sort of system here. One would allow for open primaries in the future, which would allow anyone to vote on any election, not just on the one they're registered for. And the second one, more importantly, being the one that would change any voter-approved constitutional amendment to have to be voted on in multiple years. So, for example, our amendment that got 58% and 71% would still not be law if it needed 60 plus in both years. And so adding that as another complication in addition to some of the other things that they've done, I think are the things that people should be paying attention to. Briefly, we had some sheriffs in Dayton and Broward. We had, Ray Rodriguez, Chevron Jones, Tina Polsky, Gail Harrell, Ralph Masulo, Duran, we have Gates, Shalala, Soto, Christ, Stubbe. We have a lot of different people that have sponsored, voted for, commented, and had some sort of position on this. And so I think the more we can get everybody to have a better sense of where everyone's feelings are, where that's going, may lead to what happens with litigation, statute, and implementation rulemaking from there. Because the majority of the things that have been happening have been rules that were created from the statute in 2017. There hasn't really been anything besides smokable that has really changed since then. So I hope everyone gets involved. We have a place on our website, floridaforcare.org/elections, where you can learn a little bit more, check out your voter status, know how to be registered to vote absentee by mail so you can get it sent in, make sure you send it back early. There may be delays with the Postal Service, all that kind of stuff that you may just want to be figuring out. Or if you wait until election day, there's hundreds of voting locations in some cities, thousands in some counties. You need to only go to yours. You could have issues with that. So just make sure you're informed. We wouldn't have this amendment, and we had to do it twice, which wasn't fun. And so I think paying attention to those two things are extremely important as this all moves forward as to what the system may look like, whatever your goals may be.
Awesome. Thank you, Eric. Yeah, I mean, obviously keeping an eye on the local and state elections is important. I know Tina Polsky, she put forth a bill that would help some of the employment issues that Michael Minardi was referencing before. But yeah, there's a lot of potential bills that are going to be being proposed over the next several months. So it's important to keep an eye on that. So next, I wanted to discuss the federal side of marijuana. A lot of our viewers probably know the difference between marijuana and hemp, but I want to quickly make that distinction. If the cannabis plant has 0.3% or less THC, it is considered hemp and it's federally legal. The cannabis plant has more than 0.3% THC is considered marijuana, and then it is federally illegal. So, Michael, I want to discuss marijuana bills right now here in the federal government. So can you provide us with kind of an overview of the most important federal bills relating to marijuana and the status of those bills?
Yeah, first just on elections, and just so everyone knows, you can usually go to your local county website and also be able to request a vote by mail. So if you don't want to go out with these COVID issues and stuff, you have the ability to do that. Even Trump has, approved our state as one that's safe to vote by mail. So please just make sure you vote. That's the most important thing, I think, this election is get out and vote and make your voice be heard, because who is elected has a huge impact on these laws on both the state and federal level. So with that, I think with just in the past couple of days, I don't know if it was today or yesterday, but the House of Representatives, for the first time ever, passed the basically protections to include as part of this defense budget amendment. And it's something that has protected medical marijuana businesses and states for about 10 years now. But I think it's called the Blumenauer-Hinkie Amendment now, typically, but that is the budget amendment that has been in place for a while. There's also 2 budget amendments protecting hemp, but this one is passed for the first time ever to protect legal states. So that means states that have legalization are also now potentially going to be protected from government interference for dealing in an illegal substance otherwise. So that was historic. It did pass the House. It still has to go to the Senate and pass that. In previous bouts, the Senate has not incorporated or accepted the legalization aspect of it. They have included that medical aspect of it. And just so everyone's clear, specifically what those amendments say is that no federal funds shall be used by the Department of Justice or the DEA to enforce federal law in those states that have medical marijuana law. So that's what really protects our operators and the MMTCs in this state to be able to operate without fear of federal enforcement. And that was even the case from my perspective when Jeff Sessions came out and said he was going to fight these issues and stuff like that. The Department of Justice at that time did not have any money. It is also something that has protected hemp for a while. Even before the 2018 Federal Act, there were two separate budget amendments which protected hemp. So this really gives teeth to protections for our businesses. And now again, for the first time, the big issue is legally, for legalization issues, the DOJ and the government, feds, DEA, would not be able to interfere with those businesses from operating. So I think it's a great thing. It has been used in two different cases out in California. One was Harborside, and the other one, I can't think of the name right now, is in Southern California, where the feds had tried to shut down or interfere with medical marijuana dispensaries, and either civil forfeiture cases were dismissed based on really the inability of the Department of Justice from putting any money into the enforcing federal law. Number two, everyone's been hearing that act, and I'm sure during that time, a lot of the Republicans Act and those budget amendments, because the Democrats were adding cannabis into those types of issues, and those impact us a lot. One of those issues that the House passed and was trying to add into the HEROES Act was the Safe Banking Act. And that is another option which protects and allows our MMTCs and businesses to be able to bank without any problems, without any issues with banks nationwide, or people in the state of Florida and other states to derive and get away from that cash-only business, which they then use against us because it's subject to more criminal activity because it's cash only, yet they're the ones that require us to do that. So that is still moving. The last thing, and really the most important thing for all of us, is the MORE Act. I want to make sure I get the name of that right. It's the Marijuana Opportunity Reinvestment and Expungement Act of 2019. It's my understanding there may be another vote on that in September in the House, late September. Everything has kind of been on hold, as everyone knows, with the COVID issues that they've all been dealing with. So we haven't really seen much push on these issues individually, but they have been attached to other bills. And if you're involved politically and you understand and you see what's kind of going on right now, this is a huge aspect of the debates and part of the Democratic platform of sort of changing the laws on cannabis in this coming election. I've heard that there's the possibility that Trump may at some point in time come out and support, States' Rights Act for legalization. And that's the same thing sort of the MORE Act would do. It would allow it and remove it from the Federal Controlled Substance Act, but still allow states to enact their own laws and provisions with regards to these types of issues. And that's why we believe, Regulate and me and Minardi Law also as well believe that we have to do something here on the state level to pass legalization. Even if they did pass it on the federal level, we need some sort of framework here to make it happen. And so those are things that intertwine both federal and state law, but will make it easier for us. And also, I think with, everything that's going on, jobs and tax increases, that this is something that we need to continue to push as a way to, maybe make up for some of the loss of industry that we're going to have as a result of, once we come out of COVID. So, really the federal level is trying to push things right now. Not much is going on. We're hoping to have a vote at the end of September on the MORE Act and continue to push these issues on the federal level. And this election, again, you're going out to vote, could have a huge impact on, how those tides change in the federal government. I know there's the Ross Spano, Adam Hattersley U.S. Congress race over here by me, and Adam is a proponent of cannabis, and Mr. Spano is not as much. So please get out to vote and just help us push these issues throughout. I don't know if Florida for Care does. I know National NORML does, and some other organizations. It sends out emails so that you can contact your representatives to tell them that you support these issues. And I encourage people to do so both on the state and federal level to get this thing done. I know from my federal lobbying experience, it's surprising, but almost all of the aides to the representatives and senators that we spoke to says that they do look at those emails, they do consider those calls, and they have a list on all the issues and how many calls they get for the response, pro, con. So our efforts do help. So I think that's it that I have about the federal updates right now.
Awesome. Thank you very much. And, obviously a lot of what Michael was just talking about is on the legislative side with bills and everything. But, we know that also the executive branch does have some powers to move forward legalization. So both Trump and Biden haven't necessarily taken the most supportive of positions, but with the recent addition with Kamala Harris, I know I'm hearing some different stuff about her early in her career. She was actually vehemently opposed to marijuana legalization, but more recently, as it's picked up in popularity, she's now become one of the most vocal supporters in the Senate. So Zach, I wanted to ask you on the executive side, with what we got going on with the presidential candidates, what should we expect? What should we be looking for? And do you think the Kamala as a running mate for Biden is going to have any impact on that?
Okay, first, I think she's going to have some impact. It was, those that think if Biden gets elected, there'll be a complete descheduling or decriminalization. I don't necessarily see that happening. The Democratic Party, before they went into their convention, had their, adopting their platform, and it ended up being an actual real debate within the platform committee over the extent with which they would support. So if Vice President Biden is elected, I can see marijuana, especially on the medical side. I can see it being a scheduled change potentially. I can see, potentially things like the MORE Act kind of pushing through, or, even the States Act where it would protect states' rights. A big issue, as much as it's on the executive side, is really still in the Senate. So there's only so much that the executive can do. If they can't flip the Senate, the perfect example, to kind of flip back to what Michael was saying, the Safe Banking Act, the chair of the Senate Banking Committee is not going to put it up for a hearing. So there's only so much. So it's a question of what can the executive branch do from a non-legislative required standpoint, either by executive order or agency action. And you can see a lot there. You can see potentially a loosening of the way that the financial industry interprets or views. You could see more relief coming from FinCEN and Department of Treasury. You could potentially see, hopefully, maybe some pressure put on the exchanges. I know this is completely out of what most people think, but putting pressure on the exchanges like New York Stock Exchange and NASDAQ to allow blue chip companies to actually invest and take an active role in marijuana companies. That would potentially bring a lot of the companies back from Canada that are US-based companies. And another issue that I know that a lot of leaders within the Democratic Party are pushing for is criminal justice reform, which is a big issue. And I think that, if anything, is where you could see a lot of push and a lot of weight from Senator Harris on the ticket. Yes, you're right. Early on in her career, especially as a prosecutor, her prosecutorial record was not the most favorable. She's been on record in the last few years as having, reversed and changed her opinion towards marijuana to say that she basically believes that it should just be, fully decriminalized and legal. I obviously don't see that. Vice President Biden has not gone as far. His opinion is not the same. I think that there are going to be more things that can be done that are not as, obvious, so to speak, and what can be done more on the agency level if he gets elected than, the big ticket items. But I think there's a lot of those little things will help kind of move the basket along. Getting any kind of relief within the regulatory agencies, to ease restrictions on investing in and operating in these companies. Seeing a reduction in the scheduling, especially to allow interstate commerce would be a huge, one of the issues. I know that we want to talk about more licenses in Florida, and we'll talk Florida growing and everything, but, if states where there is a glut of supply, Oregon, Colorado, California out west, the potential to be able to move that across state lines in some kind of regulated fashion, I think it'll take a little bit of time, but I think you're likely to see those kind of changes than the wholesale large, for lack of a better word, the big sexy changes that everyone expects.
Awesome. Thank you for that. Thank you for that, Zach. So I want to switch gears and talk a little bit about the hemp side real quick. So hemp was legalized per the 2018 Farm Bill, but it reserved authority for the FDA to regulate it as a food, cosmetic, or dietary supplement. This has led to a lot of confusion surrounding CBD and many of the other cannabinoids. There's even a recent lawsuit with a elderly lady who was arrested at Disney World who had CBD oil on her. So Christian, help our viewers understand the current status of CBD and what we should be expecting from the FDA in the near future.
Sure. To start, Minardi, is that a background, or is that your actual living room behind your head?
It's the background, but that's my office.
That's awesome.
Is that in your office? Is that actually in your office, Michael?
All right. Sorry, I didn't mean to knock us off track. Okay, so the important stuff that at least that I've been following at the federal level has been administrative. So specifically stuff updates from the DEA and the FDA. The DEA is way, I think, more straightforward and simpler in the sense that DEA has released proposed rules. It codifies the changes that the 2018 Farm Bill made. So just the fundamental way that the regulatory law process works, you change a statute and then downstream regulatory agencies implement with rules or regulations. And what DEA said is basically like, well, we haven't really had to jump all over this because it was obviously changed. We haven't really been enforcing things that were counter to the 2018 Farm Bill, but they've done it. So specifically, the definition of THC and marijuana extracts are changed and to be excluded from the Controlled Substances Act, meaning that legal hemp is no longer Schedule 1 as long as it's below 0.3% THC. Also, CBD-based drugs, specifically Epidiolex, are now removed from Schedule 5. So DEA has pretty publicly taken the position that they're accepting public comment on this, but they don't really need it because they have no discretion. They must make these changes, and they're just doing what the law tells them to do. And if you look at some of the quotes from Sonny Perdue, he talks about DEA has just been so openly hostile to the changes to the hemp framework since 2018 Farm Bill passed. But it's good that they're actually, getting off their duff and actually codifying this stuff, because as we'll get with the FDA, that stuff keeps lawyers up at night. Okay, so FDA. The white whale of the CBD world is clear rules coming from the FDA about what you can and can't put CBD in, full stop. So that's things like cosmetics, foods, beverages, food supplements. There's no clear guidance from the FDA on what CBD can and can't go into, because so on the one hand, without this clear guidance, the FDA every now and then has put out these little kind of skirmishes, these little nudges, basically say, now I want to remind you, this CBD is not cleared to go in food. But at the same time, every person on this, on the Zoom or this webinar is watching on Facebook is like walking around in the real world, and you see CBD and basically anything that the human body is capable of digesting. So there's clearly a disconnect where, okay, so regardless of what the position of the FDA, this is happening, and why they do nothing, it's just a mess. And so when you talk to the feds, and I'm sure, I think most of the people on this Zoom have had interactions with the federal government on this particular issue and talked to people from the FDA. But for those watching at home, when you talk to the people at the FDA, or you talk to the federal government when they're thinking about this issue, there's a few big ticket items that are like they're concerning. So the first is that just the rampant mislabeling and adulteration and we see stories, it seems like every week, about a bad actor in the hemp world that's either has misleading advertising, or their tests for CBD content is all over the place. And so they would like to, in an ideal world, that is a priority, to have consistency of labeling and have the labeling actually match the content of CBD in these products. So I alluded to the second one, but it's, false advertising, some egregious marketing and health claims that the FDA is loathes. They absolutely hate seeing that in the marketplace. The third thing is a little bit more subtle and complicated, and people are, it doesn't get talked about as much, but cannabis has kind of broken a lot of the regulatory schemes that states and now the federal government have set up. One of which is the way FDA thinks about the difference between a food or a dietary supplement and a drug. And so the interesting thing about the cannabis movement is we went through this medical marijuana revolution that laid the groundwork for adult use in these states, but also, I mean, specifically, Epidiolex is a good example of this. Epidiolex actually went through the FDA approval process. Like Epidiolex is CBD. Epidiolex is also a drug. And so FDA's brain is kind of breaking, because they're like, we've already approved this thing as a drug, but now you want to add it to food and cosmetics. And like our regulatory system isn't really set up to do that. And so they're not really particularly, I mean, CBD, the horse is kind of out of the barn. That's going to happen. It's just a matter of them trying to figure out a way to be Gumby and stretch in this totally weird, awkward regulatory position where they don't open the door to everybody who already has an FDA approved drugs coming back and saying, well, you let this thing, this substance, this compound in through both doors. We want access to that second door too. So it's definitely very interesting. FDA has actually, they have an interpretation, and they've kind of plugged it into the regulatory process. We're waiting to see what that is. People don't know necessarily what it says, but if you have any interest in the hemp industry at all and you haven't been following this, watch very closely, because I would say in weeks to a couple of months that position should be coming out from the FDA.
Hey, Dustin, just if I could just jump in real quick. Christian actually made like two really, really good points on that one, amongst all the good points. But, the first one is that these agencies, they drop these little nuggets, right? No pun intended, but they drop these little nuggets of guidance, right? That are not binding, but that the entire industry now has to go, okay, is that how they're going to turn out? Perfect example. Just like today or yesterday, the DEA put out new guidance that basically codifies the obvious. If it's legal hemp under the Farm Bill, it's out of the purview of the DEA. They don't want to deal with it. They don't care about it. That just codifies what all of us are probably dealing with when we deal with, DEA, import, export, whatever, right? They're like, okay, if it's a legal product, we don't want to deal with it. Just disclaim it. We're done.
But they'll still kick your door down for the derivative product though. Like they
100%.
They're like, okay, go do your 0.3, but
right.
We're approving hemp, but derivative products, you get over 0.3%, we're coming for you.
Yeah. And that's where the ultimate, and it's so confusing. And what a lot of people don't realize, and this is kind of the legal and science background, lesson 101. the way the industry, pharmaceutical industry and government regulatory industry was set up, right? You look at FDA is, okay, if you're developing a drug, you are saying, I'm isolating a specific protein, an enzyme, a specific chemical compound from something for use to treat this specific condition, right? I've isolated X and now I'm going to help Y. Great. Well, the CBD industry, kind of what Christian was saying, it's helping everything, you know, and the industry has partly because of, you know, no access to science and no research behind it and no FDA support for research. But, you know, it's not like someone is saying, I've got this CBD supplement that is going to specifically do this. And I've got clinical studies like a pharmaceutical drug to do this, you know, that supports. It helps your skin, it helps your back, or it helps, you know, whatever other condition. And, you know, to Christian's point, it's literally made the FDA and DEA and all the other agencies that are involved literally just be like, I don't know what's next. And they're all figuring it out. You know, USDA has basically said, once it stops being a plant, I don't want to deal with it anymore. And DEA is kind of like, well, once it's over here, I don't want to deal with it anymore. And now FDA is sitting there going, I guess we have to deal with it. But to Christian's point, we don't know yet. They just drop these little nuggets of guidance, and hopefully we'll get some clarity soon. And it's definitely created this confusion, especially with companies. I mean, I'm sure a lot of people watching would feel the same, that you just, you know, you do one thing and then a week later you get new guidance and your lawyer calls you and goes, well, I think we got to do something a little differently now.
Yes.
Yeah, and we're in a world where it's just extremely unclear. I've represented clients in responding to FDA warning letters, and I thought it would be a back and forth and I would get feedback from them, and it was quite the opposite. They did not want to give me any information. It's like I was drafting letters and documentation that was just going into a black hole. The FTC, on the other hand, they were willing to talk to me, and, you know, we had some good correspondence. But when it comes to the FDA, they're so confused, they don't even want to get on the phone and take any sort of position. So, you know, then you have to communicate that to a client, and a client's looking for a clear answer, and there's just an extreme lack of clarity. So we really need some of that FDA guidance to come out. And Christian, I appreciate you giving that background on everything. So just moving forward, I want to make sure we kind of cover as many topics as we can because we only have so much time. So after the 2018 Farm Bill, the USDA came out with interim rules that basically outlined how the hemp industry will be regulated. One of the biggest issues that was talked about was the testing requirement for total THC. So Eric, could you tell us a little bit about that total THC requirement in the interim rules and how that impacts the hemp industry?
Yeah, so, you know, I think as this industry's moved forward in both the cannabis and hemp side, you know, they've had to look at the different content of what's in these products and how they've decided that they're going to calculate that. You know, there's a variety of different types of THC. You know, there's THCA, B, there's Delta 9. And so basically they've come up with a formula as well as, you know, coming up with 0.3, you know, and they've tried to base it on the science that they think they have, but a lot of it is probably more arbitrary than anything else. And I look forward to seeing whatever comes in the future for that. But it also makes it confusing as people are trying to decide this and what things should look like, what they do look like. You know, are they going to stay the same the entire time so that they stay below? You know, what makes, you know, 0.1 more than that amount okay, but 0.1 less not okay? Is there some threshold differences there? I think that's been the major thing, and I'll let the lawyers kind of talk about the more specifics as it relates to that.
Yeah, I mean, and you know, we're seeing some states that they're trying to opt to use the previous Farm Bill and use the older THC testing definition rather than testing based on total THCs, which is how they're defining it in the 2018 Farm Bill. So I think, you know, I know there was a lot of public comment on that total THC issue, and there was also big issues as far as them changing it from a 30-day harvest time to a 15-day notice period for the testing. So It is what it is, and I think we'll have to just keep an eye on it. But I want to move forward to Florida state stuff, because I know a lot of our viewers are in Florida and they're interested and want to hear from the panel on what's going on in Florida. So probably the single biggest issue right now for the Florida marijuana industry is how this Florida Supreme Court is going to rule in the Florida grown case. Zach's firm is actually handling that case. I know Michael Minardi also mentioned that he's involved as well. So Zach, could you give us a little overview of the Florida grown case, where it's at, and what the potential implications are of that case?
So thanks, Dustin. Yeah, so just to give the brief overview, and I'll tell everyone where it is. So essentially what the Florida grown case was is that our client Florida grown was asserting and questioning why the legislature didn't have authority to set up the vertical integration system. And for those, and most probably know, but vertical integration in Florida, the regulatory system is set up that one license requires, controls everything, permit, seed to sale. And like other states where you've got growers, processors, and dispensers, here it's one company. And so the challenge was to whether or not the legislature had the authority to set up this vertical integration system, and really why Florida grown couldn't apply or wasn't eligible to apply for one of the open permits, one of the open licenses that is supposed to be there pursuant to statute. The case has kind of run through the court process for a couple of years. I'm going to try and fast track and not get into entire legal background, but essentially what we had was the trial court in Tallahassee and then the appellate court in Tallahassee sided with Florida grown that the statute as it was written differed from the constitutional amendment that was passed in 2016. Many have heard in the simple terms, the debate between and or, that the constitutional amendment listed a number of things that a license holder should be able to do, grow, process, dispense, transport, or, and in the legislature, when they codified the amendment, they created a vertical system where they said, well, each permittee, each license holder must grow, process, transport, and dispense, which locked in. I know it's a really quick explanation, so I apologize. I just know we're up against the gun. The simple answer is that the court sided with Florida grown, asserting that the statute as it was drafted differed, and the legislature didn't have the authority to go there. It's gone through the process. They had oral argument at the Supreme Court a couple months ago, which we thought went very well. The court was extremely engaged in what our Supreme Court, what our appellate lawyers have told us, and what we've now come to realize is, in what is one of the most rare occurrences, and probably one of the few times in the history of Florida it's happened, the Supreme Court has now actually asked the parties, the state and Florida grown, to come back for a second oral argument, which really never happens. Honestly, I think it's maybe happened once that we know of. Someone's going to fact check me on that, and I apologize if I'm wrong. So I'll just throw that out there. But so what we had was, instead of giving us an answer as to the issues, the court came back a month ago and asked the parties to come back in October, on October 7th, for a second oral argument, really on a specific narrow issue. And the issue kind of gets to the certain legal structures. If you can understand the way the case was set up, Florida grown was seeking what's called injunctive relief, where they were asking the court to enjoin or stop the state from acting in a certain way and make them enforce the law the way it was meant to be. There are specific requirements to getting injunctive relief, which the trial court and the appellate court have said has been there, one of which being the likelihood of success on the merits of the matter. So the court has not asked them to come back and retry and relitigate the matter or hear all the arguments over. In fact, they've only focused on this one specific narrow issue. Whether it goes to the grant of a special law to a private corporation, and the likelihood of success on the argument to that. So we're fairly confident, coming into the next oral argument, that we will still be able to succeed on the merits and that the court will find it that way. There's a real interesting issue that's going to happen is what happens next. And that's a real debate beyond, the merits of the Florida grown case, which, as I said, we think it's one way, but it's really a question of what happens next. If the court comes back and says, yep, the statute as it was adopted was unconstitutional or it was outside the scope of what the legislature had the authority to do, well, what happens next? Is it fall on the Department of Health to implement regulations? Does it fall back to the legislature to repeal and amend the statute to conform to what the court says? It's not going to open. However the court goes, it's not going to be an overnight. If the court were to come back tomorrow and say, "Yep, we agree with Florida grown, and everything must be done," and I know Christian's laughing because he and I have had these debates back and forth, and having been on the inside, he knows how the administrative process works, right? So it's like, yeah, it's going to
not
take
just
some
that.
time.
Mention one of the most prominent people who are parties on the other side of your argument. I mean, the Florida House is literally on the other side of the argument. So the concept that the Florida House is just going to be like, all right, open up.
I was trying to avoid that kind of craziness, but yeah, let's jump first into it. Yeah, so the whole debate got really crazy because the Florida House of Representatives, who was pushing the implementation law when it was first passed in 2017, they have joined the case. They joined the case a while ago, and they are the vocal party in it. They are pushing hard for the court to say, nope, Florida grown was wrong. What's really interesting about all this is, however the court comes back, if the court still sides in favor of Florida grown, this was a temporary injunction that was sought. Or a temporary injunction for the lawyers on the call, you understand that, but for everyone else, that would require this to all go back to the trial court to actually hear the merits of the issue, right? So you have two huge issues at bay, right? Is the court going to say, yep, the law is unconstitutional the way it's written, and legislature, you have to fix it, and you have however many days or whatever to fix it. Great. But then, does it going to go back to the trial court and have them actually hear the merits of the case? We think even if that happens, ultimately, the die has been cast and the legislature is going to have to change. It's just a matter of when. There's a whole lot of underlying issues, but at its root is a question of this required vertical integration. And I actually just want to make it clear. It's not like Florida grown is saying vertical integration is bad, that we want to get rid of the MMTCs. That's not at all what the argument is. And that's, not what the case is, right? So it's really a question of, should vertical integration have been a requirement, right? So Florida essentially could have vertically integrated licenses, but is it a requirement and the only way to issue licenses? That at its root is the core of the case. We think the way the constitutional amendment was drafted, that the implementation went obviously awry of that. The House of Representatives and the governor, they think differently. Hopefully October 7th, we'll have a full resolution, and shortly thereafter. I'm also hoping that the court doesn't wait too long. You never know. I mean, we could sit here and look at the tea leaves and speculate on whether or not they're going to wait till after the election or how long, and they're going to. You don't know. But at this point, it's really just how strong are the legal arguments, and we think that the legal arguments are strongly on our side, and I think a lot of people see that now, including obviously the trial court and the appellate court.
Yeah, and if I could just add a couple of things, and I think the appellate courts definitely had, and I think in one of the opinions, it was great. It said, one of the judges says, anyone who has a common understanding of the English language knows the difference between the word and versus or. But one of the things, the first DCA, just so everyone, in regards to what we think may potentially happen, the first DCA did, in their order when they issued the temporary injunction, did require the Department of Health reasonable time to write regulations consistent with the amendment. Part of this big issue is that fight, and the reason why the House is involved is because they're like, we have the power, we're the legislature, we can write any law we want, regardless of what the Constitution says. So hopefully, we will be able to bypass in many ways the legislature in getting the new rules done, because they'll be forced to be done by the Department of Health. Now, the last time we were in front of Judge Dodson, who was the original trial court judge in the floor grown case, and it was on motions to stay and to stop that case from moving forward while the appeal was happening. I think one of the comments that he made was, to me, very telling, in that I think he said, hasn't it been over 2 years now? Haven't they had enough time to write reasonable regulations? So my goal and hope that is, if it does get kicked back down to the trial court, that Judge Dodson will definitely put the teeth to them to create, if we win and get the same type of opinion the first DCA ruled, that they'll put their teeth to them to hopefully create rules and regulations within a timely manner, to be able to get this moving as quickly as possible.
And I don't think you're going to have to put the teeth. So a lot of people, people forget that the Office of Medical Marijuana Use stood up in front of JAPSI years ago and said, hey, we could go down the regulation path, and the legislature threatened to cut the Department of Health's funding. So, and there was a lot of, backlash about unelected bureaucrats creating a medical marijuana program, right? So like the Department of Health is capable of doing that. It's just politically, administratively, whether or not that's even going to be possible. But like that conversation, I think that you tell the Department of Health, you got to draft regs. There's nothing institutionally that would make that impossible for them to do.
It's funny. One, Christian, you say that like you had some experience in getting grilled from from legislators.
What those regs that say that you read about.
But this is completely separate from the floor grown case. It actually gets to a really interesting question. And I know Michael and Eric worked on the amendment, personally, I think it lends itself to a really interesting case study in what's the best way to really write a constitutional amendment and not. And a lot of people agree and disagree, and that's okay. I think it's well understood, the constitutional amendment, when it was first drafted, the idea was, how can we go, like Michael said, how can we force around the legislature? We know the legislature is going to drag their feet. What can we do, right? So constitutional amendments, they either require implementation or they're self-implementing. This one had an interesting context to it, right? It was supposed to be self-implementing, but at the same time, it also required agency action, right? Well, agencies are a creature and function of statute, and they're financed and they're funded through the legislature, and the legislature writes the law. They write statutes. So it created this real conundrum because you had a constitutional amendment that didn't say, legislature, write the law to implement this, right? It actually directed an agency to take some action, which is not something that happens often, skipping the legislature, because the legislature is the one that gives the agency the authority to do its job, right? Like Christian was saying, for all the things and all the ways that people, get on and flaw the Department of Health, I think he's 100% correct. If you told the department, the legislature, the governor said, agency, you must do this, they'd find a way to do it. But, it created this political, butting heads where we had a governor previously that was, not in favor, and many thought he just was, obstructing, the implementation, legislature that wanted the control, and you had, proponents of it that didn't want the legislature to have the control. And it created a huge confusion within the industry, outside the industry, for those pushing the matter. And I know you can simplify it, right? But it actually raises a real question of, for moving forward, people are looking at, say, an adult use amendment. Is the model from Amendment 2 in 2016 the same model? Personally, I don't think it's, I don't necessarily know that was the technical structure we should use, because it created this political conundrum. I know I probably opened a Pandora's box with that thought and that statement, but yeah, it really just kind of, I think it's an interesting question, interesting debate of how's the best way to get there and avoid obstruction.
Hey guys, I wanna make sure we keep moving forward. I know this floor grown case is this we could spend an hour talking about the floor grown case. It has enormous implications. Really at issue mainly is the vertical integration. Depending on what happens in the lawsuit, it might go horizontal in the future. We might see more licenses, but in summary, we really don't know which direction it's going to go. We don't have a lot of time, but I want to make sure we hit on one other big topic besides the vertical integration. The other thing I think most people are asking about here in Florida is recreational adult use. Michael, could you just speak for like 1-2 minutes, hit on it real quick? I know you led one of the petitions that was in 2020. What's the status of that? How did it go? What are your predictions on recreational in the future?
Yeah, so again, we're all waiting for the Supreme Court on multiple different issues, and as well as the MILF petition, make it legal. One of their decisions could have a huge impact on it. Legislature did change the law on amendments. Amendments had to comply with federal law in order to be able to be on the ballot. And so that's going to be something that we did not address it in our case because we worried. But no matter what, I can tell you that we've been working with organizations. We still have our supporters on board for 2022. Either our initiative or a new initiative will be launched by Regulate Florida to make sure that we get legalization. I don't think our legislature is going to do anything again this legislative session unless they are forced to do so by the Florida Supreme Court. I'm just hoping that we can get some hearings on legalization bills and decriminalization bills this session, which we haven't been able to either. I know, there were two representatives or a representative last year, I forget who had introduced the companion bill, but Senator Farmer had created a legalization bill that was very much modeled after and similar to Regulate Florida. So we're hoping to have that introduced again, but we need people to get out and vote, get involved, and get educated on this issue so that we can make it happen here in the state.
Awesome. Thank you very much. And I just got permission that we could go over an hour. So I want to open it up for questions. Amanda, I don't know if there's a way that we take these questions. Amanda, I guess I'll just open it up. Does anyone have any questions?
So folks, you can ask your questions in the Q&A section on the bottom of your screen. Just put them in there and we can read them. We had someone, and Michael was nice enough to answer it in text, but I think everyone should benefit from this. Is there any kind of timeline that you know for the Safe Banking Act? In addition, what are the laws that stand now on banking and merchant services for a hemp farm?
Sorry. So the status on the Safe Banking Act is really, it's the Senate. Mitch McConnell does not like marijuana, but he loves hemp, and he's from Kentucky. But the chair of the Senate Banking Committee is just not willing to put it through yet. I think it's just going to take a lot more pressure, and hopefully next year. And then merchant services is a really interesting thing. And if you're interested in that, I know we're going to have a whole banking panel coming up in a few weeks with some of the best industry experts. But in the simplest answer, merchant services is not what everyone seems. Merchant services is basically a bunch of fintech companies that have figured out workarounds that are kind of working in the gray of legality. You have not still seen the major providers, MasterCard, Visa, American Express, who back merchant services through banks, your ACH, your debit programs, willing to do it. So merchant services if someone's really interested, send me an email and I'll talk to you till the cows come home, and I'm happy to put you in touch with some of the right people in the industry. But it's still a very tough thing on the merchant services, especially for hemp. There's some available, but it's not, consistent. A lot of it, I think, is also talk to your bank and see what you can get.
Yeah, and I saw that there was a second question relating to the hemp stuff. So it seems like that's a hot topic. I know that FinCEN recently gave guidance on what banks need to do if they're going to bank for hemp clients. So it is allowed. The banks are allowed to bank hemp clients. But what I've seen with some of my clients is that the additional due diligence that they need to do, which really isn't a whole lot, but it's something, the banks just aren't willing to do. So some of these banks, I've had clients who have been rejected, but there are banks out there, and like Zach said, that the banking CLAB panel will be a really good place for you guys to openly discuss that in more detail. But the short answer is hemp is federally legal, but there is some due diligence that needs to be done by these banks, because the only distinction between hemp, which is federally legal, and marijuana, which is federally illegal, is that 0.3% THC. So it's a very small distinction. I see we have. Go ahead,
I was going to say, yeah, I saw there was a question. If you're having an issue with a bank and providing you services, shoot me an email. You know, I'm friends with a lot of the folks working in the bank industry, and I might be able to point you in the right direction to, depending on where you are, a bank that can help you. But you can just shoot me an email or something offline.
Zach, next question is, what is your email address?
I'm typing it in the questions right now.
All right. Yeah, and guys, there's ways to work through these banks as well. Stuff that, you know, I'd be happy to discuss offline also.
The answer to your question is ask your lawyer or your accountant.
Ask your lawyer and accountant. There are plenty of ways to get banked in the hemp and even the marijuana industry. So just ask your lawyer.
It's probably one of the best bright lines that you can test whether or not your lawyer or your accountant is, like, if they're a cannabis accountant or a lawyer, if they can't get you banked, they are not a cannabis accountant or a lawyer.
Right. Exactly.
I can get you banked.
So I got another question. So it says, what does the ideal legal environment look like in 5 years in Florida for the cannabis industry? I mean, I guess, you know, the question has the word ideal. I guess it depends on what perspective you're looking at. But I mean, from my perspective, in 5 years, I'd love to see the cannabis industry obviously open up, have recreational adult use, obviously be more accepted. 5 years is a long time. I mean, a lot will depend on what happens from a federal perspective. Obviously, Zach talked about some of the implications of getting federal legalization, like interstate commerce. I mean, certainly if we're able to transport from state to state, you're going to see certain states that are really good at farming become the source of farming for the cannabis industry, and really densely populated places will be really hot for retail and stuff like that. But if we don't see the federal government allowing it in the next 5 years, then we're just going to see some sort of evolution. I do believe we will have recreational at that point. But I do think it will evolve quite a bit. And certainly the hemp industry and the marijuana industry, I think, are really at some point going to kind of collide with one another. I know a lot of states right now are putting in regulations to allow hemp to be sold into the marijuana supply chain. I'm a big proponent of Florida moving forward and allowing that to happen as well. I know there's been a lot of discussions with the DOH about allowing that. But I think as that happens and you see hemp farmers selling into the marijuana industry, there's going to be a really big collision, and it's going to be even harder to make that distinction. Any of the panelists have anything to say about the industry in 5 years?
I think probably from an ideal perspective, I think it's just predictable. So like, not simple, because I don't think this industry will ever be simple, but clear, predictable rules. And because I think that's where you have the best ecosystem for innovation. And cannabis is still far and away one of the most innovative, you know, well, there's IT in cannabis, but one of the most innovative brick and mortar industries in the US, because there's so many entrepreneurs and there's so little, you know, huge multinational guerrilla corporations just dominating the sphere. And when you have that, very clear rules, we get rid of this flux about will we, won't we have adult use. A lot of people are going to make a lot of money. A lot of people are going to lose their butts, but you know, that's capitalism for you.
Yeah. And on that note, I think in an ideal world, I think cannabis would just be treated like other consumable products. You know, you'd have it be, you know, there'd be people that go the pharmaceutical route that want to, you know, get it approved for its drug uses. You'd have people that are going the dietary supplement route, and they go through the normal dietary supplement, you know, standards that they have to go through. There's people that are going to want to use it in food. So, I mean, I think there's different channels and hopefully those channels start to be treated just as other products are treated within those channels.
Yeah, I see it as a heavily taxed commodity that you know, continues to progress and be just like any other industry that we have in this country right now with alcohol, tobacco. I really see that where it'll go, and all the regulations, as you know, Christian, are basically volumes upon volumes that will keep us busy for eternity. So
Yeah, it's true. It's true.
I think that is the last question. Oh, we got one more. We got one more. It says, I'm a smoke shop in Miami, Florida that had my license taken from me after being allowed permission from Miami-Dade County to operate delivery and curbside. We sell CBD and have our license for that. No other smoke shops were shut down for it. Any help or advice on what I can do or who to speak to for help? I've been closed 6 months now, paying rent and other bills the whole time. I think this is a good time to give our disclaimer that nothing we've said in this presentation is legal advice. This is for informational purposes only, and no attorney-client relationship has been formed. But I would definitely recommend for you to reach out to an attorney on this. I'm not quite sure about what the specific issue is and why you were shut down. From your question, I can't tell. But if all you're doing is selling hemp products, you should be pretty good, and they should allow you to open back up.
you know, I'd say that there's still a lot of confusion in some of these counties and places throughout the state. We're dealing with a zoning issue currently where they don't want a CBD shop open up because they look at the definition, you know, hemp includes marijuana. They're like, and so they're trying to put it sort of under their MMTC regulations and prevent that zoning issue. Because otherwise, I really don't know why anybody would be shut down for hemp, especially after July 1st, 2019, when all of a sudden it was legalized in Florida for the first time ever.
Yeah. And one thing I will tell though, I mean, there's still a ton of hemp stores and gas stations that are selling hemp products that do not have their permit. So to the extent that you know any of those people, tell them. At this point in Florida, if you're selling hemp, I don't even care if you're just storing hemp, you need a hemp permit. If you're doing anything with, you know, hemp, at least the food products, not necessarily the inhalables yet. We're waiting on that. But if you're selling CBD food products, you need to get a hemp food establishment permit. And also, I know, Zach, we've dealt a lot with the FDA registration issue. That's a whole other topic. Short answer, it's kind of convoluted, but I would recommend that if you are running a food facility, you should probably register with the FDA. FDACS is not requiring that currently. But that is an FDA rule that if you are a food facility, you should be registered with the FDA. I think that's all of our questions. I don't see anything else. All right. Well, I see other things flowing in now. Get contact.
Basically, everybody wants your contact info, Dustin. They all want to know you.
Yeah, I'm adding it to the message board right now. All right, guys. If there's no other questions, I'm adding my email address. You're welcome to contact me at any time. I appreciate you all for joining, and we will all be in touch. Best of luck.